folks who have already had your coffee and you want to follow along with me, my article is on page 1 of your materials. And while saying that, I want to use this opportunity to thank my associates, John Paone III and Victoria Paone Rosa, for their efforts. 365 days a year, tracking the cases, doing the write-ups, and attempting to gauge with me the top 10 cases. So thank you both. Well, the pandemic is gone. And although the pandemic was a terrible thing, I must confess that I loved all the calories that went with it. But 2023 was the year to buckle down, tighten our belts, literally in some cases. And for our Section 2, 2023 was getting back to work and addressing the new legislative challenges impacting our practice. And fortunately for the family law section, it has at its helm a tireless leader who I couldn't be happier for or prouder of, our chair, Megan Murray. Let's hear it from Megan. Now to the top 10. So 2023 was another lean year, right? And why not? Half of the vicinages were either shut down, there were no trials, or things were at a snail's pace. And then even if you could get heard, the cost of taking your case to trial, we weren't getting consecutive trial days, and then going to appeal is almost impossible for most litigants. And so many chose the path of ADR, mediation, binding arbitration, and those are all good things, but they don't advance the case law. In fact, when you look at the reported cases, most of them are populated by post-judgment matters and domestic violence matters. Even the most important case that we're going to talk about today, Cardali, is a post-judgment matter. So at the end of the day, we'll see what happens. We start off a little quicker, I think, in 2024. We already have one published case. We'll see if it changes in the new year. Well, for those of you who don't really have the attention span to listen to Cardali, because you know Cardali, we do the whole symposium on, I came up with a Cliff Notes version of Cardali for you. And you can kind of take this with you if you go to cocktail parties and you want to look like you know what you're talking about, even though you may not. It goes like this. Ex-husband files a post-judgment motion versus ex-wife to terminate alimony based on her cohabitation with another. And yada, yada, yada. The Supreme Court holds that the ex-husband does not have to show proof of all the cohabitation factors. You're done. Pretty good, right? Now, when I ran that abridged version by my partner, Cassie Murphy, who was one of the scriveners of the Cardali brief, she was insulted. She said, John, you yada, 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 by the most important part of the case. So for the benefit of Cassie and the rest of you out there, let's talk about Cardali in depth. To properly understand Cardali, you need a primer of cohabitation and its impact of alimony. And it all starts with a statute passed many decades ago, NJSA 28:3425. What statute is that, you may ask? That's the statute where the legislature says alimony terminates upon remarriage. And from that statute, courts concluded that it was the public policy of New Jersey that when a supported spouse forms a new bond tantamount to marriage, which we call cohabitation, alimony should end. But butting up against that public policy is another concern, and that is the right of privacy of alimony recipients. They have individual privacy rights, the right of autonomy, the right to develop their own personal relationships the way they see fit. And it's these two competing interests which have shaped the law of cohabitation and its impact on alimony for 40 years. So in 1983, the Supreme Court is called in Gayette to make the following determination. Is living together with someone enough to terminate alimony? Some states had found just that, but the New Jersey Supreme Court said it's not enough. Again, pointing to the privacy considerations of the alimony recipients, the New Jersey Supreme Court said there had to be some nexus, some financial nexus between the third party and the alimony recipient. Either the third party was supporting the alimony recipient or the third party was living for free, and in effect, the alimony recipient was supporting the third party. This financial nexus test proved very difficult to meet, primarily because this kind of information is not something that's in the public realm. And because once the divorce is over, you can't go serving subpoenas. There's no such thing as post-divorce discovery without approval of the court. And so, over time, some clever attorneys came up with the idea of, let's make an agreement that says alimony terminates upon cohabitation, and let's ignore the financial nexus factor. Well, was that going to go by okay? Well, we didn't know until 1999 when the Supreme Court comes to Conzelman. And Conzelman says, yes, you can do it, provided the agreement is entered into freely and voluntarily, and that the parties are actually cohabitating. In other words, you couldn't say, I want alimony to terminate if my wife dates another guy. Or you couldn't say, I want alimony to terminate if my wife dyes the color of her hair to blonde. There had to be a real cohabitation. And Conzelman goes one step further. In the words of Cardali, it refined the definition of the cohabitation standard that was previously set forth in Gayet to say that cohabitation is an intimate personal relationship in which the couple has undertaken the duties and privileges commonly associated with marriage. And then they come up with the following magic, which is 5 factors: living together, intertwined finances, sharing living expenses, sharing household chores, and recognition of the relationship in the couple's social and family circle. And it's these factors together which are supposed to figure out whether or not cohabitation is being met. Conzelman never said you had to meet all the factors. Conzelman never said you had to meet the financial factors. But nevertheless, in the aftermath of Conzelman, time and again the courts were looking for the financial nexus before they would terminate alimony. Well, we take us now to 2014, and now the legislature gets into the act. They pass NJSA 2A3423N. Now, it's not just the public policy of New Jersey that cohabitation should end alimony. Now it's the law. The statute effectively codifies the factors in Conzelman. But the statute does not say that you have to meet all the factors. The statute does not say that you have to meet the financial factors. Nevertheless, in the aftermath of the statute, we have cases like Landau, Mr. Sobel's right here, row 1, seat 1, where, again, without meeting the financial factors, you can't prove a prima facie case. Finally, in a moment of enlightenment, Judge Fisher for the Appellate Division decides Temple in 2021, and he gets it right. He says, it's a ridiculous burden to ask movants at the pendente lete prima facie stage to address financial factors. That information is not in the public realm. Unless you're a garbologist and you get lucky finding things in the garbage can, where are you going to get this information? The family bar celebrated Temple. Indeed, people like Geraldine Lawrence were instrumental in getting the Temple case reported. It originally was not a reported case. But even in the aftermath of Temple, when you read the unreported case, time and time again, the courts ignored Temple and continued to look for that financial nexus. Have some doubt about that? Cardali itself is that case, where again, the financial nexus is being asked for. Now you're ready to talk about Cardali. In Cardali, the parties divorced in 2006, with the ex-husband paying $5,417 per month in alimony to the ex-wife. By 2020, the husband comes to court and he says, hey, I am looking for a termination of alimony based on cohabitation. My wife has been living with the paramour for the past 8 years. Indeed, the party settlement agreement says that alimony terminates upon cohabitation as defined by New Jersey law. The husband goes further. He produces an investigative report that shows after 44 days of being surveilled, the couple were together on every one of those 44 days, and they spent overnights on half of those 44 days. They also showed that the couples vacationed together, posted pictures of themselves as a couple on social media, and you know it doesn't really exist unless it's on social media. And finally, they also showed that they shared household chores. And yet, the trial court observes that the ex-husband submitted no proofs of any financial entanglement between the ex-wife and the third party. And therefore, this was not a relationship analogous to marriage, and as a result, the husband's motion is denied, albeit without prejudice. The matter goes to the Appellate Division, and they agree with the trial court. The Appellate Division also gives short shrift to Judge Fisher's decision in Temple, and they try to distinguish the case. and they effectively blow the husband's position away. Finally, the Supreme Court takes up certification, and they're there to decide two issues. Number one, whether evidence of intertwined finances and shared living expenses is required to establish a prima facie case of cohabitation. And number two, to what degree does the privacy rights of the alimony recipient limit the discovery to be ordered? So again, those two issues continue to fight with each other. Here now are the 6 takeaways of Cardali that you need to know. Number one, the Supreme Court holds that because the parties divorced and entered into the agreement before the statute doesn't apply. But don't worry, the factors in consummate apply. And because the factors in consummate effectively mirror image the statute, it doesn't matter whether the statute applies or not. So, for your purposes, if you're looking to make the prima facie case, whether your agreement or judgment for alimony is before September 10, 2014, the effective date of the statute, or after, it doesn't matter as it relates to whether a prima facie case has been made. The Cardali standard is good law for you. Number two, next, the court holds that movements seeking to terminate alimony based upon cohabitation do not have to present evidence of all the factors, because that would be an unfair burden. It's enough that the movement present evidence of, quote, some of the factors. Now, what does that mean? Well, let's look at Cardali. What were some of the factors that were presented? There were only 3. A, the couple were living together. B, the couple shared household chores. And 3, C, there was recognition of the relationship in the couple's social and family circle. So those 3 got them in the door. They should get you in the door. Number 3, Cardali says that the movement's prima facie burden should not be an onerous one. The movement is entitled to the presumption of truth and reasonable inferences at this stage. The court also makes clear that compelling movements to present evidence of a financial entanglement between the recipient of alimony and the third party would be an onerous burden. So now it's clear. You do not need to present evidence of a financial nexus at the prima facie stage. Temple and Judge Fisher were right. Number 4, to protect the privacy of the person receiving alimony, the Supreme Court ruled that if a prima facie case is established, discovery was to be narrowed and limited. They addressed creating the form set of interrogatories that Megan talked about earlier that her committee is working on. Number 5, when you meet your prima facie burden, you don't automatically get a hearing. No, that's an interim step now. Rather, you get discovery. After discovery's over, you submit supplemental certifications to the court. And then, only if material facts are in dispute, do you get your hearing. Otherwise, the matter can be decided on the papers. And 6, and finally, the burden never shifts. The movement always has the burden. While the burden might be a little bit easier on the prima facie stage, the movement has the burden even at final hearing. This is contrary to the position that the bar took. The bar was trying to get the Supreme Court to say, hey, the burden shifts. It should go with the party who's got all of the evidence of the issue of cohabitation, which is the recipient of alimony. The Supreme Court didn't buy it. So where does this leave us? It leaves us with a lot of work to do, I'll tell you that. That's where it leaves us, because there's so much more to flesh out in this opinion. Yes, it's going to be a lot easier to establish a prima facie case of cohabitation to obtain discovery, because now it's clear financial evidence is not necessary at the outset of the case, and the burden is not onerous. But we don't know how much discovery we're going to get. Remember, it's a post-judgment application, so the court is in control of what discovery we get. And the Supreme Court says your discovery should be narrowed and limited. Will I be able to take a deposition? I can't tell you. What questions will I be able to ask in my interrogatories? Again, that's going to be through the Family Part Practice Committee. Will I be able to get discovery from the third party? I can't tell you. Stay tuned and be prepared to make these arguments for discovery if you're in one of these cases at the prima facie stage. Next, if we get to a final hearing, here's the million-dollar question you should be asking yourself. If we get to a final hearing, will we be able to prevail without a financial nexus, without showing any financial factors between the alimony recipient and the third party? Well, The answer is we don't know. In the opinion, the court stepped aside from deciding or saying, well, if those three factors that Cardali produced holds up at the final hearing, would it win the day? It wouldn't say it. But here's what they did direct you to, and I think this is encouraging. And it is language that comes from the legislative history. Quote, before enacting the 2014 statute, the legislature considered and rejected bills that would have authorized courts to terminate alimony only if the economic benefit to the inuring to the payee is sufficiently material to constitute a change in circumstances. In the statute enacted, the financial relationship between the spouse and a third party is not itself dispositive, but is instead addressed in three of the factors to be considered by the court. And so, I believe that the financial nexus test is no longer the sine qua non of cohabitation, and you might be able to win your case without any financial proofs. But I say to you, you ignore the financial issues at your own peril. Or you better have pretty strong proofs of the non-financial issues. Remember again, Cardali, we're talking about an 8-year relationship. Think about the cases that come into your office. If they're like mine, somebody comes into my office 6 months, they're living together, and you want to go to court. Not the same type of fact pattern. Finally, and notwithstanding all this highbrow legal discussion, I believe that the courts reading Cardali will clearly figure out which way the wind is blowing. And it's blowing in favor of terminating alimony awards when recipients are living with third parties with whom they have long-term relationships. So guide your clients accordingly. Case number 2, United States versus Rahimi. I understand we have a former FBI agent here who's an associate now doing family law. You're going to love this case. I'm dedicating it to you. Hey, it's not too often that federal courts do things that impact what we do in family law here in New Jersey. But United States versus Rahimi, if you've never heard of it before, is the most important federal opinion ever impacting our law of domestic violence here in New Jersey. The case comes out of the 5th Circuit United States Court of Appeals, which covers Texas, Mississippi, and Louisiana, and it was decided on March 2, 2023. The New York Times covered the case with the following headline, quote, do people subject to abuse orders have the right to bear firearms, end quote. Well, I think that headline pretty much says what the case is about. A federal grand jury indicts Rahimi for possession of a firearm while under a domestic violence restraining order in violation of a federal law, 18 U.S.C. 922. That federal law looks an awful lot like NJSA 2C2528, which is the domestic violence law here in New Jersey, which says that if you're subject to a restraining order, you can't own, purchase, or possess a firearm. Or put another way, as I asked the presiding judge of the family part in Middlesex County the other night, of the thousands of FROs that you've entered, how many times have you allowed the defendant to keep his or her weapons after the FRO? She said, 0. So what I am saying to you is, in New Jersey, we've lived with this gun forfeiture provision for years, and many would find it hard to believe that a person who commits domestic violence would be left with their weapons. But Rahimi now puts this so-called given into question. Now, Rahimi's a bad guy, and he's been suspected of several criminal acts, separate apart from the domestic violence. But he's never been convicted of any crime. And so the U.S. Court of Appeals says, how, based upon the civil finding of domestic violence, based solely on the preponderance of the evidence, do we trump this man's Second Amendment rights? Well, the court further says, we looked at the Supreme Court's decision in Bruin from 2022, which says, if you're not dealing with a convicted criminal, you need a historical analog to show a tradition of taking guns away from bad people. The problem, of course, when you're dealing with domestic violence, there is no historical analog that goes beyond 1970. Domestic violence wasn't treated very seriously in this country, so there would be no historical analog of taking guns away from people who abuse their significant others. Probably the most ironic part of this opinion is that it cites New Jersey law in order to come up with this decision, specifically the case of Murray versus Murray, an appellate division case from 1993, no relation, Megan, But Justice Long sat on this panel, and you might remember this case, because this case talks about how domestic violence complaints are often abused by litigants in order to get an edge in the divorce case regarding child custody or with regarding possession of the home. Rahimi further cites treatises that reference pressure on family judges to grant these domestic violence orders. When in doubt, throw them out. In the words of the Murray case, "I don't love you, I don't find you attractive anymore" is the basis for a TRO. The circuit court asks, what does this have to do with taking away someone's constitutional rights to bear a firearm? What's next, the court asks. If you get a traffic ticket, beyond a reasonable doubt, you're found guilty, do we take away your guns? Finally, the concurrence notes that what happens in family court is that one party files a domestic violence complaint, and that provokes a cross complaint. And what happens? Both parties walk out with restraining orders. So now we're taking away the guns from the victims too. The court concludes that if Rahimi's a criminal, if he's convicted, if he's committed a criminal act, convict him, prosecute him, and take away his guns. But a civil disposition alone is not enough, based upon the preponderance of the evidence, and so it finds that statute unconstitutional, which would suggest that our statute is unconstitutional. The good news for you, I think it's good news, is that on June 30, 2023, the United States Supreme Court accepted certification. And in November 2023, oral argument took place. So stay tuned as to whether or not the law of domestic violence gets turned upside down as a result of the Rahimi case. Case number 3, JD versus ANW. Do you think you know the second prong of Silver? Silver was decided 387 New Jersey Super 112 in 2006 by the great Judge Robert Fall, whose gift to the family bar was this case, which is the most effective case in making a defense to non-serious domestic violence. That's because Silver says, even if you prove the predicate act of domestic violence, harassment, terroristic threats, what have you, that's not enough to enter an FRO. You have to satisfy the second prong, whereby the victim must demonstrate that he or she needs the FRO for their protection. In JD, the parties are not married, but they have a child in common. And there are civil restraints in place against the defendant, but no domestic violence restraining order. The defendant obviously has some problems because his father is required to be the supervisor of his parenting time. An episode occurs at the child's soccer game where the defendant chest bumps the plaintiff, grabs her, which results in the TRO. At trial, the court concludes that while the predicate act of domestic violence did occur, mom doesn't need the FRO. Why? 1, she has a civil restraint, and 2, defendant's father and her own husband protect her from future acts of violence. Crazy, right? The appellate division agrees, that's crazy. That's a wrong decision. These people didn't protect her from domestic violence on the day of the soccer game. More importantly, under prong 2, you cannot rely on the capacity of third parties to protect the victim when deciding whether the victim needs the FRO. And now it's time for me to give you my preaching, and maybe, Megan, you can take this up. Because there was an event that occurred in this case, which is mentioned. During the lunch break, the plaintiff says that she was harassed by the defendant in the courthouse. And this calls into question exactly what the court is doing to protect victims of domestic violence while they're in the courthouse. Remember, the TRO separates the parties, but then the court summons brings the parties back together in the courthouse. The court has a duty to protect the victim within those confines. Parties should have staggered appearances coming to court. They should stagger the time that they let them leave the court. Sheriff's officers should accompany victims in the courthouse and to their vehicles when defendants are on the premises. The failure to do these basic things is just wrong. I don't know what the court is thinking about, but when you read JD, you realize it's a problem waiting to happen. Case number 4 is Lopresti versus Johnson. I'm going to digress a bit. During the course of the year, many of you reach out, call me, email me if you have my email address, and bring to my attention cases that you think should be included in the top 10. And this case was given to me by Patrick Collins from the Skoll Law Firm. So, Pat, I thank you for that. It comes out of the Third Circuit. We're going to do it real quick, right? Third Circuit, U.S. Court of Appeals. If you have a case where you're representing a parent of an 18-year-old or older child seeking child support or seeking contribution for college, and someone comes and makes the argument that the court doesn't have the power to order said relief, rely upon Lopresti versus Johnson. Lopresti versus Johnson holds that New Jersey laws governing child support and college over the age of majority pass muster under both the due process and equal protection clauses of the U.S. Constitution. Take that case, put it in your briefcase, carry it with you to court when you need it. Case number 5, Friedman versus Friedman. Very sad case. Couple are married and divorced, they have a child in common. The child gets old enough to go to college, goes off to Colorado, and while in college has an accident and dies. Mom, without notifying Dad, has the child cremated. Dad finds out, and the dispute now is over what to do with the child's remains. The first question that we have to ask is, what are we doing in the family part? The appellate division says, you're right, you're not supposed to be in the family part. This case should have been litigated in the probate part. And so now, the child not having a will, we use the probate standards and the probate law, specifically the New Jersey Cemetery Act, to determine what happens with the child's remains. But as it turns out, when you look at that statute, the case ultimately turns on which parent had the closer relationship with the child. Mom says, no problem, that's me. Dad hasn't even talked to this child in years. Dad says, not so fast. I had no contact with my child because Mom alienated me from the child, and I want a hearing on parental alienation. The appellate division says, no, you're too late. If you were alienated, the time to raise that was at the time of the alienation, not now. Now keep in mind, Dad might have had a case here of some sort, because at the time of the divorce, there was a joint physical custody arrangement where Dad had 4 of the 7 nights. And at one point, Dad was asking for reunification therapy. But ultimately, Dad gave up and did nothing. This case stands as a reminder that when parental alienation is happening, you need to encourage your clients to challenge this in real time or forever lose that claim. Case number 6, Bronco versus Rodriguez. It's another non-family part case. This one asks the question of what constitutes a gift. Bronco and Rodriguez were not married, but they have an intimate relationship, and they lived together for 25 years until Rodriguez dies in a car accident. After his death, Bronco starts receiving checks from the estate. Well, what's this about? Well, she does some research, and what she finds out is during Rodriguez's lifetime, he changed the deed on a 16-unit commercial building that he owned and transferred title into his name and Bronco's name as joint tenants with a right of survivorship. So guess what? Bronco now owns the building. And now she asks the state for an accounting. And when the estate doesn't give her an accounting, she has to go to court to sue the estate. And what does the estate do? The estate sues Bronco and says, there was no gift here. Well, I guess now's the time for us family lawyers to bone up a little bit on the 4 tenets of gift law. Number 1, you need an actual or symbolic delivery. Well, here's the deed that was recorded. That's pretty good. Number 2, you need donative intent. Well, what was Rodriguez doing by changing the deed? Seems it was his intent to let Bronco have the property should she survive him. Number 3, there must be relinquishment of ownership by the owner. Again, the deed would seem to be clear evidence of that. Upon death, it all goes to Bronco. But number 4 is there must be acceptance of the gift. Well, how are you going to accept a gift that you don't even know was made to you? And that became a problem for Bronco in the case. The appellate division held that acceptance in this kind of a case can be presumed by the fact that Bronco did not exercise her right to disclaim the gift once she became aware of it. Now, although this was not a family part case, you all recognize this case, don't you? Because we deal with it every day. And when we deal with it, we call it what? A palimony case. The only difference here, however, was Rodriguez did the right thing. He provided for Bronco upon his death. So Bronco didn't have to sue the estate for palimony. She was provided for. The estate suing her to try to claw back the provision that was made for her by Rodriguez. Case number 7, Sachs versus Sachs. Can the family court compel a party to participate in a bet din, a rabbinical court of Judaism, for purposes of procuring a get, a religious divorce? The get was very important in this case because of the Jewish religion. A divorced wife cannot be remarried in the Jewish faith without the get. And husbands have been known to withhold gets from time to time as leverage in the divorce process. As you may remember from law school, under the First Amendment, there's a little thing called separation of church and state in this country, such that no court has the power to order a party to participate in a religious proceeding. But what if the parties already signed off on a matrimonial settlement agreement, where the party in question agreed to participate in the bet din for purposes of getting the get? In that case, which was the situation here in Sachs, the court is not getting involved in religion. It's merely enforcing a civil contract, which if entered into freely, voluntarily, and knowingly, is very enforceable, finds the appellate division in this case. Now, I believe this case was Angelo Sarno's and Michelle Wortman's case, and they did a phenomenal job in making sure that at the time that the husband agreed to give the get, it was outlined in detail in the MSA. And furthermore, the parties were put under oath to ensure that they entered into the agreement freely and knowingly. Just to quote a short passage from this agreement that was put together, which you should keep in mind in the event you have a get case. Listen what they wrote. Both parties agree to respond to any summons from a bet din regarding the get, which shall be decided in accordance with Jewish law. Both parties shall timely participate in the bet din proceeding. Both parties will answer any summons in a prompt manner. Husband represents that he may be opposing the wife's request for a get. The parties agree that their submission to the bet din shall constitute an agreement to be bound by the bet din, blah, 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 blah. Wow. These attorneys either had a crystal ball or they knew they were in for a long and tortuous history here. Again, remember, courts look to run away from religious issues, but you had such a strong record here, the court was only enforcing a civil contract. Make sure you do it the right way and read this case for figuring out how to do it the right way. If you want to figure out how to do it the wrong way, read this unreported case where Matthew Nunn prevailed. Barrett Cagedon versus Cagedon, and cited in my materials. SBB versus LBB. Okay, so speaking of gets and religious divorces, what is a woman to do when her husband refuses to give her a get? Well, in SBB, she decides to make a video to appeal to members of the Orthodox Jewish community to, quote, press, end quote, her husband into giving her a get. Apparently, the video was effective enough to encourage someone to post a message on social media with the husband's photo, which said, "This man has refused to give his wife a get. His name is SBB. He is holding his wife chained for over a year and a half. He lives in Elizabeth, New Jersey. If you see him, tell him to free his wife." End quote. I'm not making it up, right? Compounding this, the husband starts receiving anonymous calls from people encouraging him to give his wife a get because, quote, "you know what happens to get refusers," end quote. Finally, the husband also receives the video that the wife made, and from that he concludes the wife's behind all of this, and therefore he files a domestic violence complaint against the wife based upon the predicate act of harassment. At trial, the husband claimed that the wife's video requesting members of the community, quote, press, end quote, him, meant that people would be protesting against him and it would escalate to physical harm. The husband testified that being labeled a get refuser in the community would expose him to physical violence. He witnessed his own father being beaten up as he was once labeled a get refuser. The husband claimed that he wasn't refusing his wife a get. The wife testified that her intent was not to harass the husband or to cause him any harm. She stated that she only sent the video to her rabbinical judge. She didn't circulate it any further. She said she played no part in the telephone calls to the husband. She testified she had no role in the social media posting, on and on it goes. The trial judge finds the husband to be more credible than the wife and concludes that the wife's purpose in making the video was to harass, annoy, and alarm the husband. And the court also determined that the husband needed the FRO, the second prong of silver, to protect him from what would be attacks because he was being labeled a, quote, get refuser, end quote. The wife files a motion for reconsideration with a rabbinical expert who claims that the video was merely an attempt to rally the community. It wasn't any form of harassment. It was a matter of getting public sympathy. Trial judge denies the motion for reconsideration and awards the husband compensatory damages of $10,000. That's a little less than $83 million, but it's still a lot of money. The wife appeals, and the appellate division holds that the video is an exercise in free speech protected by the First Amendment. The court did not find it to be a threat of imminent danger to the husband or an incitement of violence against the husband. The appellate division says that the First Amendment does not prohibit name-calling, vituperative, abusive, and inexact language, and so the FRO is reversed. The moral of the story: language that causes someone to be shunned, embarrassed, or picketed does not rise to the level of domestic violence. Now, cases like SBB and SATS have made members of the legal community seek help from the legislature on the issue of compelling divorced spouses to give gifts to their ex. And I know that Cheryl Seiden and others are working on making this happen. They're guided by what was done in the state of New York, which enacted legislation requiring parties coming to court for a civil divorce to certify that if a divorce is granted, they will remove all barriers to remarriage. In effect, if you want the state to grant you a civil divorce, you must agree to cooperate in getting a get. It's not clear to me whether this bill will pass muster here in New Jersey, and if it does, whether or not it passes the approval of the court. So I say, stay tuned. Case number 9. In the matter of Michael D. Jones, this is a Frank Lewis referral case. And you'll know why right in a moment, right? Because this case is about the United States savings bonds. Well, how many of you out there own United States savings bonds? Right? Very few, right? I mean, when I was a kid at school, we had stamp day. It was compulsory. Everybody owned savings bonds. But today, not so much, right? But it's a possibility that your client may have savings bonds, and if they do, you're going to need to know this case. Mr. Jones gets divorced from Mrs. Jones, and the case is settled in a pretty clean way. Mrs. Jones is going to get a lump sum, ball of money, and Mr. Jones is going to keep the marital assets. After the divorce, Mr. Jones gets sick, and he calls upon none other than Mrs. Jones to help him. So much so that he gives her power of attorney over his finances. Mr. Jones has surgery, and he dies. And Mrs. Jones arranges his funeral, pays his outstanding bills, and does everything, including maintaining the home. Now, in the home, Mrs. Jones comes upon some U.S. savings bonds, which are owned by Mr. Jones, but payable upon death to Mrs. Jones. The beneficiary designation was made prior to the divorce, at the time when the bonds were obtained, and was never changed. Well, Mr. Jones takes the $77,000 in bonds to the banks, redeems them, and puts the money in her pocket. Now, at this time, Mrs. Jones is probably saying to herself, who's going to complain about this? Well, you know, in life, we don't trip over boulders, we trip over pebbles. And the pebble in this case was a child, an adult child that Mr. Jones had from another relationship. Interesting, we didn't hear about this adult daughter when Mr. Jones was sick, but now the adult daughter files for administration of her father's estate, and among other things, seeks to recover the $77,000 bond proceeds from Mrs. Jones. Now, it appears that the adult daughter has a pretty strong case, because there's no doubt that pursuant to the divorce agreement, Mr. Jones kept all the assets of the marriage in return for the lump sum. And there was never an allegation here that these bonds were not disclosed, such that there was some kind of fraud going on. What the wife says is that the MSA doesn't specifically list the bond as an asset. And she claims that Mr. Jones's failure to redesignate beneficiary of the bonds was evidence of his intent that Mrs. Jones was to be the beneficiary. The trial court doesn't buy Mrs. Jones. First of all, I mean, when we all write up an MSA, we don't do a bill of sale, right? We don't list every darn asset there. But more importantly, the trial judge says under NJSA 3B3-14 the beneficiary designation of the bonds were automatically revoked upon death. And so the trial court rules in favor of the appellate daughter and against Mrs. Jones. Well, but Mrs. Jones goes to the appellate division. And now she has a new argument, a new and improved and better one. And that goes like this. Under federal law, you can't change a beneficiary of a U.S. savings bond unless you take the bond to the government agency, which in most cases is a bank, and you fill out certain forms to have the bond reissued with a new beneficiary. Mr. Jones didn't do any of that. The appellate division says the law of preemption barred the trial court from applying the New Jersey statute, which he claimed revoked the beneficiary statute, and therefore the bond proceeds were awarded to Mrs. Jones, the wife. Two big takeaways from this case. Whenever the law prevails over equity in the family part, the results seem wrong and unfair. Here, Mrs. Jones clearly received a windfall. She wasn't entitled to the bond proceeds, and yet there was nothing a court of equity could do about it because federal law controlled. You might remember last time we had a case like this was Vittori versus Vittori concerning federal disability pensions. In that case, Judge Maulla went so far as to vacate an alimony waiver in order to make things right. The court couldn't do that here. Most important for you, as a result of the Jones case, you now have a duty to advise your clients about making inquiry into beneficiaries of U.S. bonds they are keeping pursuant to the divorce decree. So in that letter that you already sent about changing beneficiaries of life insurance, 401k, IRA plans, blah, 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 make certain you address U.S. savings bonds if they are in your case. Final case number 10, EW versus WMH. For one person in my office whose name will go undisclosed, this is her most favorite opinion of 2023. The opinion is written by Judge Joshua Sanders in Essex County. It's a trial-level opinion. The parties had a brief dating relationship. They produced no children of their own, but plaintiff had a child from a different relationship. The parties have a dispute about monies plaintiff handed over to the defendant. Specifically, plaintiff claimed that she was swindled by the defendant, who told her that he was a government assassin. You don't believe it? All right. Defendant also threatened the plaintiff that if she took any action to recover the money from him, he would have her child taken away from her by filing a DCPP complaint against the plaintiff about her smoking marijuana in front of her child. Now, digressing for a moment, I find it very interesting about how these government assassins really work, right? They use the deep state, DCPP, to accomplish their goals. Very clear indeed, right? Anyway, the plaintiff is undeterred by the threats of the assassin. She proceeds with filing the litigation to get back her money, and the very next day, an anonymous complaint is filed with DCPP alleging that the plaintiff is smoking marijuana in front of her daughter. Now, I have to tell you, at this point, I don't even know if that's a thing anymore. I mean, if you take a kid through the hallways of most of these hotels, you get more exposure to marijuana. Anyway, plaintiff believes that the defendant filed a DCPP complaint to harass her for making collections efforts against him, and she files a complaint under the Prevention of Domestic Violence Act and obtains a TRO. At the FRO hearing, there's no direct evidence that defendant filed the DCPP complaint, nor could there be, right? Because reporters have confidentiality and immunity. But the trial court nevertheless concluded that based on the testimony of the parties, the plaintiff being more credible than the defendant, the preponderance of the evidence was that the defendant filed a DCPP complaint, and he did so with the intent to harass the plaintiff. But what about the immunity that reporters get for filing DCPP violations? The court finds that that immunity protects reporters from civil and criminal liability. It does not act as a defense against domestic violence. Now we get back to the second prong of silver that we've been talking about all morning. The court found that there was no evidence of prior acts of domestic violence. The parties had not been in contact with each other since their separation. And so the plaintiff did not meet her burden to show the need for the restraining order, so the FRO was denied. I think this case found a fan in my office because, especially when you handle high conflict custody litigation, it's not uncommon for parties to file bogus DCPP complaints. And the question has always been, what can you do about it? Well, with EW, at least you have some authority for taking action under the Prevention of Domestic Violence Act to address this type of harassing conduct. And with that, my friends, you have the top 10 of 2023.